morning, gentlemen. All right. All right. So you can see.
Thank you, Your Honor. May it please the court, John Lancaster, Anthony Williams, LLC for appellant Ralph Jason Shorter.
Mr. Anthony, do you want some time to recall?
Yes, I reserve 5 minutes for
You
both.
sure can.
And just to clarify, I'm John Lancaster, I just work Anthony.
Oh, I'm sorry. I thought I heard Anthony. I saw Anthony's my fault. Last name is what?
Lancaster.
Thanks.
This deals about due process. It's fairly simple, chain of facts.
Where is the due process founded? Is it the lack of notice or lack of formal notice or informal notice doesn't apply? Give me your best argument. on
Yes, Your Honor. The notice issue, the notice was insufficient to
that.
provide
As a matter
notice
of
that
law?
Mr. Charette would have to file a paper within a certain period of time to avoid an entry of an order.
He's strictly a creditor, correct?
Yes, Your Honor.
Is he entitled to formal notice or just informal? notice?
On this particular proceeding, he would just be entitled to informal notice, Your Honor.
So he was given time to respond and chose not to respond?
He was not given a time to respond in the notice. He was given an
But
indefinite
in
amount of time to
reality, the
respond.
calendar gave him 30 days, correct? He had 30 days to respond if he chose to respond.
Prior to the order being entered, yes,
So
Your Honor.
you basically, you're writing something into the rule that isn't currently there?
Well, Your Honor, I don't think that's the case. With respect to hearings, Florida Probate Rules 5.42C provides, and I'm quoting, copy of any written petition or motion which may not be heard ex parte, and a copy of the notice of the hearing thereon shall be served at a reasonable time before the time specified for hearing. This indicates to me that motions under the probate code require a hearing.
Was there a time specified for hearing the notice?
There was not.
And that's your complaint, essentially?
My client did not know when its response to the compromise
And
motion.
he was not
had to be
represented, he was not represented by attorney? at
He
that
was
time?
represented by a counsel, yes, sir.
Okay, so nobody told him, whether it was the attorney or the court or the clerk?
That's correct. No, there was no notice that provided that information. There was no rule. Sometimes there's an administrative rule that trial courts have that says, well, if you don't file a response within 15 days, a party can submit an order and request that it be determined on the papers. There's also case law that talks about, well, if you go ahead and you file a response and a memorandum of law, then we'll go ahead and determine the matter on the papers before. That wasn't the case here either. Mr. Charette didn't file anything. So there's no formal notice or other documentation that would provide Mr. Charette.
Well, I mean,
notice
what
that the
you're
amount of time.
describing is essentially a desktop review. That happens in the probate court very frequently. They get a file, time's up, they make a decision based upon the filings of record.
And if there was in fact a formal notice provided, then that would be appropriate. But in this case, it was just a motion.
But you said I thought you said formal notice was not technically required.
For this particular proceeding, you're right, Your Honor, that's what I said. If you are going to have a estate opened and closed very quickly, generally they provide formal
Well, it
notice
was
to
that
the
quick,
people.
was it? When you have a gentleman commit suicide, money's missing, there's the 1031 Stark Exchange Fund set, and no one bothers to petition until tail end of this situation.
Well, my client was actually the petitioner for the administration of the decedent.
And that triggered someone else with allegedly greater standing
Yes, Your Honor.
petition, and then the judge decides who to appoint.
Yes, Your Honor. And they requested that they be appointed. We asked for a fiduciary. They asked that the person named in the will, who obviously has higher standing.
Yeah.
They took over. There was a mediation. A few days after the mediation, there's a settlement agreement and a motion to compromise under 718.7, or excuse me, 733.708.
Well, but hold on, was your client notice of the mediation date?
There was they did provide notice
So
of
that's a
mediation
yes.
date, but what
Your client knew the date of the mediation, and your client knew that this was between Lovelace and the estate, and maybe somebody else. Now, from reading the record, your client sure does have a lot of complaints about Mr. Lovelace. A lot of complaints. And so when he gets the motion of personal representative to approve settlement with William Lovelace, the same person that he has all kinds of accusations, true or not, he sits on. So you're telling me that the motion says if you have an objection, it needs to say if you have an objection, file a hearing, this and that. He's got a lawyer. He's got a lawyer. So he didn't file an objection, correct?
I think it was his position.
So
that
do you want us to reverse this because the lawyer didn't file an objection?
I think the position is that Mr. Charette felt as though he wanted to
Well,
respond.
feelings
He
are
needed more
wonderful, but they
time
mostly
to-
lie.
He needed more time to prepare his objection because he did have a lot of
Okay,
things
so
to say
did he
about
ask
Mr.
for more
Lovelace.
time to respond?
No, he didn't, Your Honor,
Okay.
but there was no deadline.
Oh,
Is it too simple to say that Mr. Charette was expecting there to be a court hearing and there wasn't a court hearing?
That's a very,
Isn't
I
that-
think that's a
isn't that-
very fair read on it.
Taking it one step further, there doesn't have to be a court hearing.
I think under 5.042C, in the reading, there's some commentary out there. There was a similar language in the old 1.510C, which provided for summary judgment prior to the change in the summary judgment statute, that the responses had to be filed within so many days prior to the hearing, and the fact that prior to the hearing was in the statute, was in the rule. The fourth DCA, Kozich versus Hartford Insurance Co. of Midwest, Florida fourth DCA, and also Travelers Insurance Co. versus Florida Medical Center, Inc., both brief. They reversed summary judgments where the court failed to conduct a hearing. And it's analogous.
Probate cases?
Excuse me?
Are you saying probate cases?
No, those are based on 1.510. The analogy is
no,
that
that's a
5.
summary judgment. This is just approving a settlement, which for all indications on its face, it appears to be an agreed to settle.
Between Mr. Lovelace and the estate,
Right.
but not Mr. Charette, who was not invited to the mediation, that I wasn't there.
Right. Well,
I
the
imagine
judge
it's
gets
what-
it, the judge gets it, we all got it, we all were circuit judges. Motion to approve settlement, look around and ask the JA, any objections? No, judge. Sign.
It was submitted as agreed. It was entered only a couple hours after it was submitted. There was no time. Obviously, Mr. Charette, if you'd seen the order submitted, he would have taken time to file a motion for extension time or whatever else he could have done to
It seems like-
stop
it
the
seems like
entry of
a
that
lawyer should-
agreed order, which really wasn't agreed by all the interested parties. But interested parties are more broad than just the two parties to a motion to compromise. And in actuality, and under the statute 730-31, they are actually, anybody who's reasonably foreseen to be, have an interest in a particular proceeding is an interested party. And I'm sorry, that's 731.20123. So if Mr. Charette was an interested party, he was entitled to notice, he was entitled to due process. It's Mr. Charette's position that he wasn't given due process because he wasn't given a reasonable opportunity to be heard. He believed that he would have until there was a hearing to file paper of record or to make his objections known at a hearing on the motion, and there just was never a hearing. And citing the case law that was presented, there are some cases that say there's no need for a hearing on a non-evidentiary matter. It really just mostly dicta. The First one being Gaspar versus Naples Federal Savings and Loan Association, Florida 5th DCA case from 1989. Very distinguishable in that case. It was an administrative order. And the administrative order allowed the court to make a determination after a issue had been briefed by each party. And based on that administrative order, the court entered its order without a hearing. Distinguishable, there was no briefs from each party here, there was just the motion in this case. There is the Newdale case versus Flagstar Bank. That case is also distinguishable. It really had nothing to do with whether there needed to be a hearing in order to enter an order. It was a motion to disqualify, and the judge and the court went ahead and entered an order. It was all briefed, and there was a footnote in that case. And finally, what's been cited is First City Development of Florida, Inc. versus Hallmark of Hollywood Condo Association, Florida 4th DCA case from 1989. It's basically stands for the premise that if a objection to a discovery request is filed, the judge can make a decision based on the objection and the request without a hearing. It goes no further than that. Those are the only three cases that were cited for the proposition that you don't need to have a hearing. Each of those has a mitigating factor. There's been something filed. There's an administrative order. There's an ex parte sort of relief sought, and irreparable injury will occur if it's not entered without a hearing. When you look at all of the various exceptions to the general rule and the hearings necessary, none of them fit this purpose and this cause. Under the circumstances, Mr. Shred takes the position that there should have been a hearing. In fact, the appellees argued in their briefs that it was a practice. In fact, Mr. Gibbs says, we looked at what happened with the Jack Martin settlement that we had previously had. We actually had a hearing on that. There was some questions about that. And the court said, well, 30 days, provide them with the documentation. If nobody objects in 30 days, then we'll go ahead and we'll enter an order. They tried to make this analogous to that. And Mr. Gibbs repeatedly used, who was representing the state, repeatedly used the word, I deemed this the same as that. I was deeming. Well, deeming something doesn't necessarily make it true. It's very discretionary and subjective. And under the circumstances, deeming a prior practice or procedure that was used with respect to a prior settlement motion is a violation of due process in and of itself, because again, it's just deeming it. Nobody had ever said that this was the deadline for this motion and that no hearing would be necessary so long as there was not an objection within 30 days. For those reasons, appellant asks that the compromise order with William Loveless be vacated and remanded with instruction that for the proceedings after time of discovery to address that motion appropriately. Thank you.
Thank you. You have 5 minutes. Good morning.
Good morning, Your Honor. Timothy Weber here on behalf of William Lovelace. Mr. Gibbs, who represents the estates, indicated that he was ceding his time to me this morning in the interest of expense to the estate. The appellant in this case admits that they received informal notice under the probate rules of the motion to approve this compromise. And so they further admit that they were provided all of the discovery documentation that had been exchanged between the estate and Mr. Lovelace.
So their arguments due process. They're entitled to more than simply notice.
Correct. So they received notice and there's no question of notice. And then the appellant just argued again that they were not given a reasonable opportunity to object. And I would submit that 30 days to say something, I want a hearing on this, I object to this, I have some issue with this, is a reasonable opportunity to object. Particularly under, the typical Matthews v. Eldridge analysis, due process is a flexible concept that depends on the nature of the rights that are at stake and, basically the circumstances of the
It depends on the
proceeding.
rules.
And here,
The rules were followed in this case, correct? Probate rules.
it was submitted, the court had said previously to the personal representative, to Mr. Landcamer, hey, he's gonna file everything, he's gonna circulate it to the creditors. If no objections are filed within 30 days, upload an order and I'll sign it. That was done on June 9th in connection with the settlement of a quote co-defendant's case in this petition. Jack Martin, the court had all the lawyers there and said, this is the process I want to follow. And when she denied the rehearing in this case, she specifically referenced her instruction to the lawyers, file your objection.
Yeah, I didn't really argue about the rehearing prong of the appeal. So if you want to respond, it's fine.
Yeah, so our response is twofold. Number one, they were given notice and a reasonable opportunity to respond. Certainly at the point in time an order is uploaded, and if you think at that point that, your due process rights have been violated, are you calling chambers, are you filing something saying, hey, wait, not so fast? No, Mr. Charette waits till the 15th day following entry of the order, files his motion for rehearing, and importantly, in his motion for rehearing, he makes no substantive objections.
Is that a timely motion, by the way?
There is authority for a rehearing motion. in
The judge
appropriate
regarded
matters.
as timely was denied.
It is timely and authorized at that point, but he makes no objection to the settlement in the motion for rehearing. And then he's afforded a hearing. And when he's afforded a hearing, does he come to the hearing with his objections to the settlement? No, he comes to the hearing complaining about his due process rights. And so his motion for rehearing still doesn't make any objection to the settlement on the merits. He just says in there, I anticipate making objections. He wants to have full discovery and a trial and to relitigate the case that Mr. Lovelace thought he was settling between himself and the estate. And so that's what the motion for rehearing is solely fixed on, was I wasn't given due process before this order was entered, yet he's afforded a hearing. He's given a rehearing and he schedules it non-evidentiary. He makes no substantive objections in the motion for rehearing. He presents no evidence. He doesn't ask the court for an evidentiary hearing. He wants to focus his entire rehearing on the unfairness of the court entering an order after waiting 30 days. And so that's how the rehearing goes. And I would submit, as a matter of due process, that he had a hearing. He had an opportunity to come to court and say his piece. Now, he makes a vague reference at the rehearing to, well, I don't believe the appraisal that Mr. Lovelace had on the office building property. We think it was low. Does he present an appraisal? Does he present any countervailing evidence? Any impropriety or unfairness or anything in the settlement? Not a peep. He just complains about this process of this 30 days before he's, an order is entered. And so at this point in time, we hear arguments about Rule 5.042, and he's trying to compare that to the summary judgment. He doesn't raise 5.042 in the trial court. He doesn't raise it in his initial brief in this court. We hear about it the first time in his reply brief. Oh, that's the rule. So this is not about the probate rules that weren't raised or argued below or in the initial brief here. This is about due process. And I would submit on the whole of this record, he admits he's received full notice and given all the information pertaining to the litigation between the estate and Mr. Lovelace. He's given at least 30 days to file an objection. Another 15 days after the court's order, he still files no substantive objection. And under those circumstances, and then he's given a hearing, which he noticed as a 30-minute non-evidentiary hearing. Now he says in his reply brief, oh, well, I was, told that that's all I can do. There's no record evidence of that. There's no record evidence of him requesting an evidentiary hearing on the settlement. Trying to present any evidence on the settlement. Of him having any evidence in opposition to the settlement. And so under the circumstances, it was reasonable for the court to look at the motion to compromise, wait 30 days, and particularly in this case, this petition that was filed traveled against 3 defendants simultaneously. So the court has a hearing in April and says, we're going to resolve all 3, boom, 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 June 9, June 10, July 15. She was treating all 3 of these matters in a single petition as one. The lawyers show up on June 9th, and the estate and Jack Martin's lawyer announced, we have a settlement. All the lawyers are there, they're all listening. Judge says, here's the process. Circulate all the information to the creditors. If no one objects in 30 days, I'll enter an order. Mr. Langhammer, aware of that process, tries to say, well, that was only on Jack Smith, and she didn't say that specifically on Loveless settlement or anything of that nature. Clearly, the court afforded creditors of this estate an opportunity to say their piece. Mr. Charette was simply dilatory in doing that. He never filed a substantive objection. There's a reference to an objection on November 29th, but that objection is actually to a settlement with Janet Lopez, the decedent's wife. And so he never filed a substantive objection to the settlement with Bill Lovelace. For these reasons, I would respectfully submit on the sole issue presented to this court, whether Mr. Charette was afforded due process of law, that he was afforded adequate and ample opportunity to present his concerns and failed to do so. We'd ask the court to affirm. Thank you.
Thank you, Mr. Weber. Lincoln.
Thank you, Your Honors. With respect to the commentary concerning what happened at the Jack Martin hearing. The Jack Martin hearing was different. It was set on a different date. It was traveling under the same paper, but there was a hearing. At that hearing, the parties started talking about settlement with Jack Martin. And in the context of Jack Martin, the trial court specifically stated, with respect to Mr. Martin, if you have an objection, you circulate the information. If somebody has an objection in 30 days, I'll have another hearing. Only about that. The months later, this motion that and the order that we are here on today came up. Mr. Weber wasn't there. He would he did not make a notice of appearance until weeks after that particular hearing. The motion for rehearing transcript shows what the parties that were there heard. Mr. Eisel, who represented Jack Martin, said, yeah, it was applicable. This 30-day period was applicable to Jack Martin. Mr. Gibbs indicated, well, we didn't want to have an unnecessary hearing, so I deemed it applicable to deemed.
Well, I
Deemed it applicable
that
to.
explains his argument and strategy. That's not binding on the court.
He deemed it. That was he deemed it himself. The court never ordered it. He deemed it to be sufficient and sent it to. And he marked it agreed. The order said agreed. If I understand, Chief Judge Sleep, a court gets an order and nobody's filed an objection, the court signs it. That's especially likely to happen if that order says agreed. In this case, my client didn't agree. The only interested parties that agreed were the 2 parties to that mediated settlement agreement. With respect to the rehearing, and you heard about, well, there really wasn't anything substantive that talked about at the rehearing. The 45 days, or excuse me, at the rehearing, the trial court judge, probate judge, didn't say anything about the substantive portion. All she wanted to know about was whether there was a due process issue or not. I had asked Mr. Weber for discovery. Mr. Weber had indicated, representing Mr. Lovelace, he had indicated, there's already a final order on this. We're not giving any discovery until after the final order is adjudicated. There was no basis to compel discovery or to do anything else to put forth a substantive presentation. The actual order itself doesn't say it was denied because there's no substantive basis for me to reverse this order. What the order does say is that it's denied because you failed to take action within 45 days after the order was entered. It was timely under a rehearing standard. I understand that something could have been done more quickly.
Got 30 seconds.
But again, there was not due process here under the law, and we would request that the order be reversed and the case remanded for further proceedings with instruction after discovery. Thank you.
Thank you both. Well argued. Thank you very much. The next case. Concerned citizens of Tarpon Springs, Inc. versus City of Tarpon Springs et al.